Okay, so Assalamualaikum warahmatullahi wabarakatuh. My name is Haslina binti Kalang with metric number 0595.6, and today I will be presenting the presentation of Part A, which consists of the topic crimes of aggression. So for the introduction, when a political or military leader of a state causes that state to use force illegally against another state, they have committed the crimes of aggression, provided that the force used constitutes a violation of the United Nations Charter in its character, gravity, and scale. Aggression is a very serious crime that carries a maximum sentences of life in prison. The International Criminal Court (ICC) has jurisdiction over 4 different types of crimes, and one of those crimes is known as the crime of aggression. The offence that is outlined in Article 5 of the Rome Statute was put on hold until the state parties were able to come to an agreement on a definition and the terms of application. This was accomplished during the Kampala Review Conference in 2010 and adopted by the Assembly of State Parties in December 2017, allowing the court to exercise jurisdiction over acts of aggression commencing in July 2018. In light of this, on July 17, 2018, in honor of the International Criminal Court 20th anniversary, the jurisdiction of the court was expanded to encompass the crime of aggression. So what does it mean by the crimes of aggression? An act of aggression is defined as any instance in which one state uses force against the sovereignty, political independence, or territorial integrity of another state, or in any other manner that is in violation of the United Nations Charter, as stated in paragraph 2 of Article 8 of the United Nations Charter. This term extends to include any other circumstances in which a provision of the United Nations Charter has been violated. An act of aggression is considered a crime under Article 8, Clause 1 of the Rome Statute if it is planned, prepared, initiated, or carried out by a person who is in a position of power to effectively control or direct the political or military action of a state, and the act of aggression, by its nature, gravity, or scale, constitutes a violation of the United Nations Charter. In addition, the act of aggression must have been carried out by a person who was in a position of power to effectively control or direct the target. To put it another way, a person who has the position of power necessary to successfully control or command the political or military action of a state, regardless of whether or not the action in question is political or military in nature. Next is the historical background of crimes of aggression under the Rome Statute. In 1974, the General Assembly of the United Nations voted to accept a definition of the crime of aggression. Despite this, the definition was riddled with antiquated conceptions that were developed during the Cold War, which undermined the definition's ability to serve as a guide for normative behavior. This was primarily due to the fact that the definition was being used by the state as a strategic asset, and the state was attempting to obtain control of it so that they could use it to their advantage against their geopolitical adversaries. The primary reasons for this was the fact that the state was using the definition. As a result of this, the legacy of the Nuremberg Tribunal has resulted in the unfulfillment of a hope because, since 1947, no other accused perpetrator of this specific crime have been convicted. As a result of this, the hope that the wish would be fulfilled has been dashed. In spite of this, the academics and participants in the Rome Conference in 1989 recognized the crime of aggression, and it was included as a considerable addition to the jurisdiction ration material of the International Criminal Court. The offense was classified as one of the most serious crimes that should be of concern to the international community in accordance with the principle of the Statute of Rome, which stipulated the terms of the statute. Despite this, the International Criminal Court was not allowed to exercise its jurisdiction over this matter since the nature of the crime could not be established with absolute certainty. During the first session of the Assembly of State Parties in 2002, a special working group was established with the task of preparing a road to resolve the primary concern that arose with the definition of the crime of aggression. This road was to be presented and discussed at the second session of the Assembly of State Parties in 2006. The ideas that were finalized in 2009 by the Special Working Group on the subject of aggression serve as the foundation for the definition of the crime of aggression that was eventually agreed upon at the Kampala Review Conference in 2010. Next, over whom will the ICC have jurisdiction with respect to aggression? Well, first of all, the ICC have jurisdiction with respect to aggression over the UN Security Council. In the event that the United Nations Security Council refer incidents to the International Criminal Court, the court will have jurisdiction over the individuals involved in the scenario being brought to the court. There may be nationals of ICC state, parties that have approved the Kampala modifications. There could be nationals of ICC state parties who have not accepted those amendments, or there could be nationals of states that are not party to the ICC. The understanding on these aggressive changes that are attached to the resolution that adopt the Kampala amendments make all of these points very plain. Therefore, the jurisdictional framework that is outlined in the Rome Statute for the other crimes will also apply to the referrals made by the United Nations Security Council. Even in the event that the Security Council makes a referral, the International Criminal Court would not be able to exercise jurisdiction over crimes that are specific in an amendment if those crimes were committed by citizens of ICC state parties that have not ratified the amendment in question, as stated in the second sentence of Article 121, Clause 5 of the Rome Statute. However, there was a widespread and perhaps universally shared understanding among the states that were parties to the Rome Statute that the second sentence of Article 121, Clause 5 was not to be regarded as applying to referral to the Security Council. This understanding was the Rome Statute did not apply to Security Council referrals. Second is over the non-parties or states that are not parties to the Rome Statutes. Regarding the jurisdictional regime of aggression at the ICC, we have already seen one change in the case of state referrals and prosecution proprio motu. This change differentiates the jurisdictional regime over aggression from jurisdictional regime over other crimes in relation to national of countries that are not parties to the treaty. The Rome Statute gives the International Criminal Court the authority to investigate and prosecute crimes committed on the territory of states that are parties to the treaty by nationals of states that are not parties to the treaty. However, according to Article 15, Clause 5, the court does not have the authority to investigate or prosecute a crime of aggression that is alleged to have been committed on the territory of a state party by a national of a non-party. It is possible to question whether or not non-parties can recognize the jurisdiction of the International Criminal Court with regard to aggression by merely making a declaration to that effect in accordance with Article 12, Clause 3 of the Rome Statute. Article 12, Paragraph 3 enables for these kinds of disclosure to be made in relation to the other crimes covered by the ICC. According to our interpretation, the language of Article 15, Clause 5 is unequivocal in its assertion that the court does not have jurisdiction to hear cases involving alleged acts of aggression committed by nationals of non-parties or on their territory. accepting such pronouncements would also put states who are not parties in better position than states that are parties to the conflict. The states that are parties to the ICC are prohibited from taking any action that could give the International Criminal Court jurisdiction over an alleged act of aggression perpetrated on their territory by nationals of a state that is not a party to the ICC. If this were the case, it would be rather peculiar if non-parties were granted permission to enable the court to exercise jurisdiction not only over aggression committed by their own nationals, but also over aggression committed on the territory of non-parties by nationals of states that are parties to the agreement. And last but not least, is over the states parties to the Rome Statute that do not ratify the Kampala amendments. According to what has been stated, the challenging jurisdictional matter pertains to aggression perpetrated by an International Criminal Court state party that has not ratified or recognized the Kampala amendments. It is possible for states that are signatories to the Rome Statute to opt out of the ICC's jurisdiction for acts of aggression. But what about the state that is a party to the Rome Statute but has not ratified the Kampala Amendment and has not opted out of the court's jurisdiction over aggression? If one begins with the Kampala Amendments, Article 15, Clause 4 may give the impression that the International Criminal Court will have jurisdiction over acts of aggression perpetrated by state parties regardless of whether or not those state parties have ratified the aggressive amendments. Also, if the normal rules of ICC jurisdiction set out in Article 12 of the Rome Statute apply, then aggression committed on the territory of a state party that has ratified the Kampala amendments by an ICC state party that has not ratified the Kampala amendments will be subject to ICC jurisdiction. However, there are a number of reasons why the narrow view should be preferred. Specifically, the view that the International Criminal Court does not have jurisdiction over aggression committed by an ICC state party that has not ratified or accepted the Kampala amendments and has not opted out of the ICC jurisdiction over aggression. These are the reasons why the narrow view should be preferred. And to conclude, the International Criminal Court was established with the primary mission of promoting not just justice but also peace throughout the world. There has been a great deal of criticism leveled at the International Criminal Court for neither of these things. Nevertheless, the ICC also faced some significant political and structural challenges. On the one hand, it is constrained by a lack of resource and the limit imposed by institution, and it is subject to the influence of state. In addition to this, the International Criminal Court has been accused of practicing selective justice. In spite of all of this, the International Criminal Court has the potential to serve as a guiding light in the promotion of international justice and peace. It could also serve as a deterrent to the commission of crime because of the clear threat that its prosecution poses to those who commit serious crimes. It has been argued that the International Criminal Court's ability to contribute to international peace and justice in the larger context of international affairs depends on the institutional power and support it receives from the state, in addition to the ICC's own work in an impartial manner. So that's all from me. Thank you.